Welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we make sense of the law one bite at a time. Whether it's live trials or splashy legal headlines, we are here for the facts in the law and no nonsense. Well, unless it comes from our furry four-legged friends, of course. Here is where you bring your unique perspective to agree or disagree with other people, but please, always in a way that's civil and productive. After all, we're here to get to the bottom of the truth with a capital T, and the best way to do that, of course, is with healthy dialogue. So, if that's what you're looking for, jump on in. We would love to have you. Let's get started. What do you guys think about the new intro? I just worked on that today. Yeah, let me know what you guys think. I like it. I really like it. It's got a good groove, right? But I know I gave a preview, a sneak peek to folks that were in Bike Club today, the members only stream. The one critique was that we no longer have puppies on a grill, like the previous intro we had. But I might see if maybe I'll update it if I can find that footage again. So anyhow, welcome. Good morning, good afternoon, good evening. I hope you guys are having a happy Friday. It's the end of another week. Isn't that wild? Anyhow, love to see you guys. So obviously, we've been living in New Mexico for the last couple of weeks, right? We've been in the Russ trial, the Hannah Gutierrez Reed situation, talking about armorers, talking about guns, talking about live ammunition versus dummies versus blanks. Now we are in Michigan, still talking about guns, still talking about involuntary manslaughter, but it's a different kind of a case, right? So for those of you that are not familiar with the James Crumbley case, this comes out of the Oxford school shooting that happened in 2021. Obviously, tragedy. So don't let the groovy intro fool you, right? Like, this is a very sad case, obviously, very tough one. And this is one of the reasons why I wanted to cover this case with smaller live streams and videos, do some recaps, things like that, because I know that there are a lot of folks that are interested in this case, but don't necessarily want to live in it, right? Because when we cover it gavel to gavel, you kind of feel like you're living in it. And sometimes it's hard, and school shooting cases are just really, really hard. So I wanted to do this kind of a treatment for this case, this trial, cover it overall, but just in more like bite-sized pieces. So here, this case, like I said, it comes out of Ethan Crumbley's case. Ethan Crumbley was a teenager. He shot his fellow students at Oxford High School in Michigan. It turns out that his parents had apparently bought himself a firearm and had taught him, to use a firearm, despite knowing the fact that he had some mental health issues. So Ethan Crumbley was sentenced to life in prison in December. After that, Jennifer Crumbley, his mother, went to trial last month. So she was convicted of involuntary manslaughter, 4 counts of it, because there were four students who died, and I think seven were injured. So now James Crumbley is on trial for the same thing. This is not about the school shooting itself, but how, could he have prevented it? So because involuntary manslaughter in Michigan has there are a number of ways to describe the elements, but this is how I list them out. Number one, death was caused by something that someone did. 2, the defendant was grossly negligent in causing that death. 3, that death was foreseeable from that gross negligence. And 4, there was no lawful excuse or justification for the action or inaction by the defendant. So here, the main allegation here is basically that James Crumbley knew that his son had severe mental health issues, and that he was around. He wasn't exactly off traveling, for like work trips or things like that. He knew that these things were happening. He decided to buy his son a firearm. He decided to train him on firearms, and he also did not properly secure that firearm. Basically, like putting this gun in his son's hand and making this possible to happen, knowing that something like this could very well happen. This was basically what the allegations were against Jennifer Crumbley. Like I said, she was convicted. There are a lot of people that look at this case in some different ways because, in the United States, Second Amendment is a very big deal. There are a lot of people who are concerned about a case like this where one person does something and someone entirely different is held responsible related to firearms. But on the other hand, I think that this case is unique because of the specific knowledge that the parents are alleged to have had in this case. So I don't think that this is like, every single case that involves a school shooting now will have the parents be charged. I don't think that that's necessarily going to be the case. However, parents in those cases are probably going to be looked at pretty closely, with this case in mind to know to understand, did they know that there was a problem? Did they do anything to correct it? Did they have steps that they could have taken that were reasonably easy that could have prevented such a tragedy? Things like that. So that's what this case is going to be looking at. So in this video, we are looking specifically at the opening statements because opening statements are so important. I love looking at opening statements. I love looking at closing arguments because opening statements are all about, a good opening statement gives you the framework for how to think about this case, how to go about this case. And it gives a roadmap for what you can expect from, the prosecution, what you can expect from the defense in terms of witnesses, in terms of evidence, in terms of what kind of promises are they making to you, and will they be able to keep those promises later on down the line? So because you can have an amazing opening statement that makes a ton of promises and then later on down the line you get to closing arguments and then you realize, oh, they didn't keep those promises. They weren't able to. You know, for example, in the Hannah Gutierrez Reed case, the defense made promises that they had so much information that proved that Seth Kinney brought the live rounds on set. I think that they were successful in casting suspicion on Seth Kinney. I don't know that they were able to give definitive proof like it seemed like they were able to do, or that like they were saying that they were able to do. So, okay. Now, as we go into it, I'm going to be tracking the questions you guys have. I'll save them or answer them in the moment if I can. And also, yes, sorry, I've been ignoring it because it's been like in my background for the last like 20 minutes. But Mr. Bites gave Indy a bone or a rawhide, and she loves these rawhides so much that she starts crying. So I apologize. I hope it's not a huge disturbance for you guys, but she is crying with tears of joy right now because of this rawhide. Okay. I might need to take that away from her in a minute if she doesn't stop. Okay. Maybe she's looking for a place to hide it. Oh no, she's just curling up. Okay. Bog Frog, was this the same school shooting where the mother was recently convicted? Anyone know? Yes, that's the one. Jennifer Crumbley is the mother who was convicted. So that's the same exact one. So remember, this is less about the actual events of the school shooting, although that was the harm, right? The harm was 4 people died, 7 people were injured. It caused death. That is one of the essential elements. They will be hearing about that in this case. But the main focus here is on what did dad know? What was dad aware of? What did he ignore, if anything? And what did he do? What did he not do that he was supposed to do? Those kind of things. Those are the main questions that we are going to be asking. Draco Amy Live, thanks so much for that trigger warning. Anytime we're talking about these kinds of cases, that's a good idea. You might need to step away for a while, mute or catch this next stream. Look after yourself. 100%. Zero shade, zero fault on anyone who needs to take a step away. This is a tough case to get through. So thank you, Draco Amy, for putting that up. And then we also like to have the mods put up the numbers for folks that are feeling distressed, mental health helplines. We've got not just the US, we've got UK, Australia, Canada, as well as Germany and Greece. So we'll flash those on the screen from time to time as we cover this trial. All right, folks, let's get to the opening statement, shall we? Oops, here we go. Okay. And I've already boosted the sound because I noticed that the sound on the stream is a little bit low. So I apologize if it's still a little low. I've already boosted it as much as I could. So I hope that's okay for you guys. I hope the sound is okay. Let me know either way. Oh, also, I should have said this before. As always, state has the burden of proving this case beyond reasonable doubt. So state goes first, defense goes second. When it comes to closing arguments, it will be the same thing. State goes first, defense goes second, but state then also has a rebuttal afterwards, short rebuttal where they respond to the defense. The reason for this is because the state has the burden of proof, so they get the advantage of going first because they are the ones that have to prove all the things. Defense has the disadvantage of going second, but they have the advantage of getting to hear everything that the state just said and responding to it. So that at the very least, that's in closing, right? In openings, it's like each side is making their case for how this should be presented. So there's generally no rebuttal there, but in closings, that's why there's a rebuttal, is because the state can't respond to the defense if they go first, right? So it gives them a limited ability to respond. Carolyn V, we should get a pre-poll. Okay, I'll start that. I'll start the stream and then I'll put up a poll. So.
On November the 30th, 2021, James Crumbley's 15-year-old son walked out of the boys' bathroom in Oxford High School holding a 9mm handgun. James Crumbley's son walked out, he pointed, he aimed that 9mm and fired it 32 times over the course of the next 9 minutes. He fired that weapon at teachers and students. He killed 4, wounded 7, and terrorized the entire community. James Crumbley bought that gun that his son used to kill as a gift for his son 4 days before the attack. James Crumbley failed to secure that gun in a way to prevent his son from accessing it. Anna was 14 years old. Madison Baldwin, she was 17. Tate Muir, he was 16. Justin Schilling, 17 years old. These are the 4 students who never made it home that day. What happened inside that school was truly a nightmare come to life. But it didn't have to. That nightmare was preventable. There are 3 people in this world who are criminally responsible for the deaths of Hannah, Madison, Tate, and Justin. The shooter who committed murder, no doubt he's responsible. But so are his parents. But not for murder. They're responsible for their gross negligence, for involuntary manslaughter. Because that nightmare was preventable and it was foreseeable. The shooter's case is done. The shooter's mother, Jennifer Crumbley, her case is done. You're here to decide the level of gross negligence of James Crumbley. And you will learn throughout this trial that he was the adult out of anyone in the world in the best position to prevent these kids' deaths.
Boom. That's a really strong start right there for the state. So far, starting with the emotions, the emotional, like the story of what happened. It's a short story, right? It's very short. He walked out into the school brandishing a weapon, et cetera, right? This is what happened. It's emotional from the very start. You have the sense of the weight of the reality of what happened in this case. So this is a very, very strong start to hit the jury first with the emotions. Like, you can't tell me that they're not paying attention after that introduction. Very strong. And also just like the level of emotion in his voice also feels like he's upset. Like he's mad that this happened. Like he has like, righteous indignation over like this having happened. So it's a very, very strong start. And also the thing that he just said there, that Ethan Crumbley had his turn in court. Jennifer Crumbley had her turn in court. Now it's James Crumbley's turn. And out of all of them, or at least aside from Ethan Crumbley, out of any other adult, James is the one who was most in a position to be able to do something. So in other words, all these people have already been dealt with. Get a load of this guy. It's even worse. Buckle up. So very, very strong start to this opening statement so far.
You're going to learn that those kids would still be alive today had James Crumbley seized any one of the tragically small and easy opportunities given to him to prevent his son from committing murder. Any one of them. These were opportunities that were literally given to him, yet he disregarded.
That's also a very, very strong statement to make in opening statements. This is a promise here that he's basically promising to them, you will see that there were easy things that he could have done, super easy things that he could have done. It wouldn't have taken much effort at all, and it could have prevented life lost. Jury is now going to be looking at, what were these simple things that he could have done? Are they really simple, or are they more complicated than this prosecutor is leading us to believe? Jury's going to be looking for that. And so this is he's giving them exactly what to look for. This is what I mean by establishing a framework for the trial. This is really good so far. Flash Fan 85, is this a live trial? This is from yesterday. But the trial is ongoing right now. Today's day 2 of this trial. So Rare Aussie, so he killed 9 kids and the parents knew he was going to do it. He killed 4 and I think injured 7 or maybe 9, he said. But four of them died. The parents didn't know that he was going to, well, I don't know if you can say that. The state is alleging that they knew that he had a firearm. They knew that he had been pulled in by a counselor with some very suspicious stuff. I'll let him say it in his opening statement. So he'll do it better than I will. Yeah, it's they had awareness of issues and didn't do enough to prevent it. That's what the state is alleging. Also, Christina M. question: is this the same judge as the mother's trial? I believe so. For better or for worse.
During this trial, you're going to hear about events from the spring of 2021 through December of 2021. November of 21 is the critical time period, especially November the 30th. But that earlier evidence is going to give you some context into the family life in the Crumbley household. It's going to give you some context to learn that the shooting didn't just happen out of the blue. The shooter didn't snap. What happened was foreseeable, especially to his father. I'm going to talk to you about some of the evidence that you're going to see through this trial. And we'll start with this. This is a 6-hour 9mm handgun. This was a firearm purchased by James Crumbley as a gift for his son on November the 26th, 2021. This is a picture taken by the shooter, found on his phone, the day that gun was brought home. This is a Instagram post from the defendant's son. The next day, November the 27th, 2021. That's after his mom took their son to the shooting range to practice with that gun. Took my new SIG out to the range today. Definitely need to get used to new sights, LOL. This is a post from Jennifer Crumbley, the shooter's mother, the defendant's wife. That same day, November the 27th of 2021. Mom and son day testing out his new Christmas present. My first time shooting a 9mm. I hit the bullseye.
Now, this is really important here because these social media posts establish that this wasn't just a firearm that the parents bought that, the state is somehow claiming out of thin air that they bought it for their son. This shows very clearly that they bought they bought the firearm for their son, not that they bought it and he happened to get a hold of it. This is something that is very different than I think every other school shooting case that we've seen, because all of those other cases have been where the person who was the school shooter, either got access to guns, through by buying them on their own because they were old enough or something like that, or you know they the parents just on that day didn't lock away their firearms well enough, and kid got into it. They didn't intend it, but it was not the kid's gun. It was like the parents' gun at home. That's in a lot of ways different than this, right? Because this is where they bought it for their son as a present. And so this is very important to establish kind of the difference between this case and a lot of other situations where the parents thought they were doing things properly, but like the kid got into the family firearms, or the parents' firearms or something like that. Now, keep in mind too, I know that we've got a lot of folks that are in here that are international. In the US, there are a lot of people who will have fired a firearm before they're 18. I learned how to shoot a firearm at 14, 15, 14, I think. It was in a very limited, kind of circumstance, but, but yeah. Anyway, but it was not totally uncommon for that to happen. Him having fired a firearm at the age that he was isn't necessarily a huge deal to a lot of people in the United States. For other people, it might be alarming on its own. But there are quite a few people, and I would venture to guess that in Michigan, in this jurisdiction, that there are people who I do know that there are people on the jury who are gun owners. So there are people who probably would think, okay, I mean, so long as you're safe, so long as you are doing it in a very controlled environment, in a controlled, very kind of way, safety first kind of thing, it is possible to take a 16-year-old or a 15-year-old to a gun range, teach them how to use a weapon, and that kind of thing, and have, father-son time, mother-son time, kind of thing, that on its own is not alarming. But what the state is going to continue to talk about is that there are all of these other things that made that incredibly alarming. So let's continue.
You're going to learn that it wasn't just those 2 extra magazines for the handgun in the plastic case that came with it when James Crumbley made that purchase. You see, he was given the tools to make that firearm safe. He was provided a cable lock. It was provided by the manufacturer, by Sig Sauer. It went to the firearm dealer who sold it to James Crumbley. It was for that gun. This is what it looked like the day the gun was purchased, November the 26th, 2021. This is what it looks like now. Still in its original packaging, still with both keys in the lock.
This is really, really important here because this is the cable lock that was supposed to secure the firearm. It's supposed to keep it from being accessible. The fact that it's in the original packaging shows that it was never used. So was this ever properly stored? I don't know. I'm sure that the defense is, probably going to point out some other kind of, ways in which they secured the guns or something like that in their home. But this is a really strong piece for the state to start off with.
It was never used. The decision that James Crumbley made to buy that gun as a gift for his son was made even though he knew that his son was in the midst of total and complete social isolation and had been in a downward spiral of distress that had been going on for some time.
And there it is. That's the part right there that makes it very alarming that the state says, this is all allegations at this point, right? Evidence comes out. That's what ends up proving the case to the jury. But here, this is the state is pointing out, they bought him a firearm. They didn't lock it properly. They knew that he was having some serious mental health issues.
You'll see evidence that as early as spring of 2021, the shooter had expressed to his one and only friend that he had asked his father for help. He told him to suck it up. That was in April of 2021.
That's also.
You learn that instead of receiving help or intervention of any kind, James Crumbley instead began to take his son to the shooting range, even buying himself a .22 caliber Kel-Tec semi-automatic pistol, and his son a different gun, .22 caliber two-shot Derringer. That was June of 2021. They would go to the range together on a consistent basis over the next few months. We have evidence of a number of trips, and you'll see some of that.
And again, there are people out there that probably will think, okay, him taking his son to a range is not crazy. Like that on its own is not crazy. You know, there are plenty of people in the United States that do that. The question then comes in though about the mental health issues. How much did they know? Was it foreseeable? So far, in my opinion, the state is doing a fantastic job of laying all of these pieces out.
Some of this background is going to shed light on what happened in November of 2021.
By the way, I love this Michigan accent. It's been a while since I've hung out with folks that are from Michigan, but like Detroit area especially, it's just like I know I've got friends and family from the Midwest and whatnot, so I love a good Midwestern accent.
This is a pivotal month in the Crumbley home. As I said, the shooter had one and only one friend. That was no secret. James knew about that. You're going to see evidence that the shooter and this friend would communicate with each other throughout the day and throughout the night. The level of data on that text message conversation alone dwarfs everything else on the shooter's phone. You'll hear evidence that there were over 22,000 text messages in just 1 year between the shooter and his friend. Those two shared quite a bit with each other. This is the friend that the shooter confided in when he asked his father for help. That friend was taken from the shooter at the end of October 21. He didn't just move schools and go to another town. He was taken out of state without warning, without notice, and without a way to communicate. The impact on the defendant's son was severe. His entire social connection was severed, and James was there to know about it. You see, he wasn't working at that time. From November the 1st to November 9th, he didn't have a job. And when he did work before that, it was from home. When he did get a job on November the 10th, it was for DoorDash, where he could set his own schedule and decide when he did work and when he did work. It was also during the...
This is an interesting point here because he's pointing out the flexibility of James's work, having worked for DoorDash. If there are people who are perhaps blue collar or have worked, Uber or DoorDash or something like that, they might take some issue with that because, just because it's a more flexible kind of job, it's a lower level kind of job. That doesn't mean that he's not trying to pay the bills. He could have been very focused on trying to pay the bills in whatever way he could in between jobs. Because it's, I can tell you, I used to drive for Uber for a short period of time, and just to pay bills in between things, while I was waiting for bar results, and it was actually a really fun job, to be honest with you. But it was like, it was one of those things that's like, that's not my career, but that was the in between thing, and yeah, I was very focused on it to pay those bills, so that is something that some people could potentially take issue with, but I also understand his point that he's saying he has a flexible job too. So anyway, Zulishan, thank you so much for becoming a YouTube member. Welcome to Bike Club. Very, very happy to have you here. The Lucian working DoorDash for full time is not actually that flexible. If you are trying to bring the money in, if it's supplemental, then yes. If it's for full income, then no. It requires more hours than most. I mean, yeah. There's a lot of in between time with those kind of jobs, right? I mean, yeah, it was like I said, with my experience with Uber, it's like it can also depend on where you're doing it too, because it's like there are some like geographic locations. I can say from my experience having driven for Uber in Southern California, it's like Friday night, Saturday night in like the beach cities of Orange County was like a great time. Other than that, it was, you had to be strategic to be like, okay, I would like drive people like early in the mornings on weekdays. Then those would be like airport runs where people were like, going to work somewhere. So you you still have to like manage your time in a certain way that isn't necessarily that flexible, although it may look flexible on the surface. But was that the case with him? I don't know. I mean, I feel like we're going to get details on that to figure out just how flexible this was. Also, just because, thank you so much for gifting 10 Legal Bites memberships. Very kind and generous of you. So let's see here. Charmed, Flash Fan 85, Francisca Cruz Arancibia, and Mary M, Carolyn, let's see, Brittany Pratt, Jacob Therian, Paul Hanbury, and Satellite Girl. You have all been gifted memberships by Just Because. So welcome or welcome back to Bike Club. Very, very happy to have you guys here. And thanks again, Just Because. Very, very kind. So, okay, here. Let's see. Any other questions here that are good to well, this is more of a comment. Pimp Poppy, sometimes it helps people's mental health. PTSD helps people PTS people use gun. I mean, I can understand that too, that going to a gun range can also have a focusing and calming effect for a lot of people. I can definitely understand that. That also is folks outside of the United States might not understand that so much, but where it's a different kind of mental health issue here than PTSD in my opinion. So let's see here. Also Flash Fan 85 this is a jury trial, right? I think I read somewhere where they said this is a bench trial. No, this is a jury trial. This is a jury trial that they actually had a lot of good information about it. One thing that I'm sorry to interrupt this with a little bit of a side quest here, but one thing that was very interesting about this case, because it's the third one and because it's gotten so much publicity, is that James Crumbley requested to have the jurisdiction changed for this case. Judge denied that, but what she allowed was to have way more people in the jury pool that they could potentially pull from, and she allowed the defense to have more peremptory strikes. Meaning, so we've got when you've got strikes when it comes to picking a jury, you've got like strikes for cause, and then you've got peremptory strikes. For cause means somebody comes in and says, I absolutely am biased. There's no way that I can see the other side of this. I've already made up my mind. They say that, and that's a for cause strike. Like, you have an unlimited number of those. And that's basically like the two parties go up, they talk to the judge. Judge says, yeah, let's let this person go. A peremptory strike is where someone comes in and they're not necessarily saying like, well, I'm 100% biased one way or another. But they have something that suggests that they might have a bias. They might have some extra experience that you don't particularly want them to bring into the deliberation rooms. Maybe they work in a certain area that is too close to this case. There's things like that can be a reason to strike someone that isn't a causal strike. And a peremptory strike can be literally any reason or no reason at all, other than an illegal reason, meaning a discriminatory reason. You can't do it on the basis of someone's religion, their race, their gender, or anything like that, sexual orientation, things like that. But they made a funny look when you said something. 100% you can. They're wearing something that indicates a particular alliance. Yeah, you can strike them for that. Here are some of the questions that they asked potential jurors with things like, do you have an Oxford Strong, sign in your yard? Because if you do, you're probably going to be very biased against this defendant. Things like that. How much of the trial did you see? Et cetera, et cetera. Let me see here. Actually, let's see if I pull up some notes here from that just really quick, and then I'll get back to it. I promise. Yeah. Did they watch the Jennifer Crumbley trial footage? Have you ever been a victim of a crime? When you were a teenager, how often did you keep things from your parents? There are things that could go one way or another, be either beneficial or non-beneficial to these people. So here it was. Okay. So the jury in the end consisted of 9 women and 6 men, and it took 2 days to seat all of them. They include a retired music teacher, a retired nurse, a machinist, an engineer, and numerous parents, several of whom also owned guns. So this is an interesting makeup of the jury. So long story long, Flash Fan 85. Yes, this is a jury trial. Okay, Shiro Kana, sorry to ask, what is this case about? This is involuntary manslaughter, the responsibility of a parent over his son for a school shooting. That's it in a nutshell. If you want to go back a little bit early in the stream, I give a little bit more detail. And question, when did the original incident occur and how long did the shooter get sentenced for? The original incident happened in 2021. I want to say December 2021. And he got sentenced for life without parole. All right, let's get back to it. And also I'm going to end the poll now, and then that way we can have a poll at the end of the opening statements so that folks can let me know what they think at that point.
This month of November, that the defendant's son began to write in a journal. Some of that is going to be permitted to be shown to you, and Judge Matthews decides what you see and what you don't see. The portions you'll see is that the defendant's son wrote about how he was begging his parents for help, how he's begging for a more powerful 9mm handgun to commit the school shooting, and how he's able to obtain access to the murder weapon.
This is also really interesting here because he's referring to evidence that isn't going to be admitted, and not the journal that he just detailed. But what he's referencing here is the fact that there is more stuff that's bad that they can't see because the judge decided that. Not every court is going to allow that. Not every court's going to allow that, but here I guess it's okay. So this way he's signaling to the jury, if you think that there's not enough evidence here, it's only because we weren't allowed to bring it in. So I don't know. Some people might feel one way or another about that. But hey, judge has allowed him to do it, so why not? It's strategy, right?
Again, this evidence is important for you as background to what happened on November the 30th, but it also gives you a glimpse into the level of knowledge possessed by James Crumbley when he made the decision to buy that Sig Sauer 9mm handgun for his son on November the 26th. And then, just as importantly, what he decided not to do the morning of the shooting. You see, James Crumbley was afforded what might have been the easiest, the most glaring opportunity to prevent the shooting. A full 3.5 hours on November 30th before the first shot was ever fired. Yes, he was shown this. This is a math worksheet. These are drawings and writings from the defendant's son, November 30th, 2021. One of his teachers saw him doing this, took a picture of that, and sent it to the shooter's counselor. The counselor came down and took the shooter out of class, brought him to his office to find out what was going on. You will learn it took that counselor all of 20 minutes to decide that immediate parental intervention was required. He made that decision even though he had about a fraction of the knowledge possessed by James Crumbley.
This is an important point for the state also, because remember he said that if James Crumbley had taken one of the many easy steps to prevent this, that he could have prevented it. It was tragically easy was the phrase that he used. This kind of like echoes that he says the school guidance counselor, when he got wind of this, he in 20 minutes with a fraction of the information that the parents had, knew that there was something wrong, knew that he needed to call the parents in immediately for their, to to address this issue with their kid, because this was a serious problem. So this is we're juxtaposing one person's reaction to the parent's reaction.
You see, this drawing, as well as an altered version created by the shooter, were both sent from that counselor to Jennifer Crumbley, who shared it immediately with James Crumbley before they arrived at the school. The severity of the situation wasn't lost on James or Jennifer Crumbley either. They expressed their concern about what they see here, the words "help me," blood everywhere, a picture drawing of a gun, of a person with 2 bullet holes in blood. They expressed their concern about that drawing to themselves in Facebook messages. This is Jennifer Crumbley, she's in blue. "Call now," all caps, emergency. This is November the 30th, 2021 at 9:33 in the morning. Followed simply with emergency. Then she sends her husband, James, the defendant, both the original drawing as well as the altered version of it that the shooter created. That's at 9:38 in the morning. James Crumbley's response: "My God, WTF."
That's his response to
And then
the photo.
he says what he was actually doing that morning. "Vet not here. It's McElmurray's for Purist horse. Still waiting on the vet." You see, James and Jennifer Crumbley spent quite a bit of time away from the home, tending to their horses. That's what he was doing the morning of the shooting. Jennifer Crumbley: "He said he was distraught about last night." James: "We talked about it this morning." "You talked to him?" Jennifer: "Can you call?" Then heading to his school: "I'm very concerned." That was at 10:04 in the morning.
I've got to say, for me, it's a little bit troubling that he's like, "Well, I'm still waiting for the vet." This seems like the kind of situation where the vet can wait. The horse can wait. This is your child. This is very disturbing what's happening and very, very troubling. So it's already, if I'm a juror, I'm looking at that and I'm saying, "Oh God, I'm already seeing some mistakes by dad."
Unfortunately for everyone, they kept that private concern to themselves. They didn't share it with the school counselor. Despite what they knew, despite what they thought, James Crumbley and his wife, neither one of them, mentioned anything about the gun being purchased for him 4 days before the shooting.
Ooh.
James Crumbley didn't say a word about how that picture of the gun that his son drew looked identical, that you will see, of the 6 Sauer 9mm. They didn't say anything about the prior request for help. James Crumbley didn't mention anything about the severity, the real circumstances of the shooter's friend being taken from him. They didn't just fail to inform in that meeting, though. They also failed to act. It was recommended at that meeting that James and Jennifer Crumbley get help for their son then, immediately, that day. And they were provided with a list of resources with mental health providers that would fit any budget, any insurance plan, or even no insurance at all. But they didn't. James Crumbley didn't do anything. Jennifer Crumbley didn't do anything. Neither one of them called. They didn't take him home. The reason given to the counselors that they had to work. But James didn't mention that as a DoorDash driver, he set his own schedule. He didn't mention that he hadn't even signed in for the day for DoorDash yet. He was at the vet. Or that as a DoorDash driver, he was able to just put his son next to him in the car. It was one of those glaringly missed opportunities.
Yeah, the proximity of days between purchasing it and then 4 days later. So I previously said December 2021. The shooting happened on November 30th, 2021. The gun was bought on the 26th. So the proximity of those is really damaging to the defense. I mean, it makes it seem like they just basically put it directly in his hand almost for the purposes of this.
Instead of seizing that incredible opportunity that was before him, James Crumbley spent the next 2 hours driving around town making deliveries, never once bothering to stop by his house, which is just a mile away, to check on the whereabouts of the gun that his son drew. Even when he drove by the house to do so, never once. The gun that he knew was kept unsecured. That is until after the Oxford School District sent out an email blast to all district parents of an active shooter situation. You'll learn that that email reached James Crumbley about 1:10 p.m. And by pure happenstance, James Crumbley was at the exact location that parents of Oxford high school students were told to go in case of emergencies. The reunification point was the mire on Ray Road next to the high school, directly adjacent to it. By pure coincidence, he happened to be at the exact location where hundreds of people were scrambling to get to. But he didn't stay. That's when he went home. That's when he went home to look for the gun. And that's because he knew. You will hear that there was one and only one person who called the police that day to identify their kid as the suspected shooter. It was James Crumbley.
Yeah, this is interesting because it's like what they're suggesting is that it was already in his head that this was a possibility, and yet he didn't go home first to check to see if all of their guns were secure, and instead decided to go about his business. You know, interesting stuff. Jay Trudeau, interesting comment. But the guidance counselor also decided that Ethan wasn't a danger to the school after the meeting with the mother, but he got immunity, of course. I mean, and I fully expect the defense to bring that up and really hammer that in as well. However, the counter argument to that is going to be, which we basically heard in this opening statement just a minute ago was, they didn't tell him all of this other information. If the guidance counselor had known that they had just bought him a firearm, that, all of this stuff that he was dealing with the friend being gone, etc., that, if the guidance counselor had known all of that, he would have decided completely differently. So that's probably the counter argument that the state is going to give to that point. But I fully expect the defense to harp in on that. Legal Vices, thanks so much for the super chat. Very generous. This is such a twisted, odd, strange case. Good to see solid coverage in odd time zones. Right back at you. Thank you so much. And yeah, it's such an interesting case. Like I said before, about the fact that this is, parents being held responsible for their kid, shooting up a school. I know for some people, they're really championing that. Other people are very concerned about that. But I understand both perspectives. All righty. Okay, let's continue on.
Nightmare, these murders were preventable by him, foreseeable by him. During this trial, you're going to hear from between 15 and 20 witnesses. I do need to tell you that you won't hear from the shooter. Neither side is entitled to call him to the stand. You won't hear from Jennifer Crumbley. Again, neither side is entitled to call her to the stand. But you will hear a lot about what happened in the days, the weeks, the months before the shooting, specifically November the 26th and November the 30th. Again, those are the critical days. What happened from the 30th, from the time of the meeting to the time that first shot was fired. You're going to learn that throughout the investigation, investigators obtained information from social media accounts, from cell phone forensic analysis. They obtained banking records. They obtained GPS pings. So you're going to be able to put together a bit of a digital footprint of the Crumbley life. You're also going to learn what James and Jennifer Crumbley did after the shooting. Evidence will be presented to you to show that the defendant and his wife withdrew as much cash as they could, and they tried to liquidate their assets. They were found hiding from the police in the city of Detroit in an art studio on December the 4th, 2021. That's after they were charged with these crimes.
Yeah, that's also consciousness of guilt right there. When someone's, I've seen it even when someone wasn't, was just interviewed by the police and then let go and not told that they couldn't go anywhere or anything like that. And, we saw that in the Caitlin Armstrong trial, the love triangle murder trial in Austin, Texas, involving the cyclists. She went down she got herself all the way down to Costa Rica, used her sister's passport, got some plastic surgery to change her face. The defense really tried to argue that was just because she wanted to do a yoga retreat because she really loved yoga and she would travel for yoga. But that one was like, it was just so clear there that was consciousness of guilt was what was pushing that move. This looks very similar, not because, of those extra things like that. Like, they didn't go very far, not quite like Caitlin Armstrong did. They didn't get plastic surgery or anything like that, but they had already been charged when they decided to abscond. So that's going to be pretty damning too.
Which you will never hear, and I want to make sure this is clear, you will never hear any allegation that James Crumbley knew what his son was going to do on November the 5th, that he bought the gun knowing what his son was going to do. If he bought a gun knowing his son was going to commit mass murder, then he'd be charged with murder.
This is important to clarify very early on for the jury so that they know what they're looking for. They're not looking for him to have known that his son was going to go into the school and use that firearm. But rather, that they should have known of the risks involved with all of this, like the totality of these circumstances.
There's no claim that James Crumbley gave his son that firearm hoping he would murder 4 students. So then the question becomes, how is it that a father can be held responsible for the intentional acts of a teenage son? And the answer to that question is twofold. There's 2 reasons. First, it's important to remember that James Crumbley is not charged with murder. He's charged with involuntary manslaughter. Murder, or aiding and abetting murder, is an intentional crime. Involuntary manslaughter is rooted in negligence. It is by definition causation in an unintentional killing. Second, it's because it takes a rare and specific set of circumstances to rise to the level of involuntary manslaughter when there are multiple causes of death. A rare set of circumstances. Those rare circumstances you will find present in this case.
This is also, I think, I have a feeling that this is to address sort of the concerns that a lot of people have about, like, well, if my kid does something wrong like this, and I've done everything that I can to prevent that, but they still manage to get access to the guns, etc. Like those kinds of things, those kinds of, people. This is to say, this is a rare set of circumstances. This is a unique kind of case. And in order for them to be convicted on this, it has to be rare circumstances. Those circumstances are present here. That's important to get to clarify early on in this case too.
It takes gross negligence. It takes causation of death. And it takes that other person's acts to be reasonably foreseeable. Those are the 3 elements that must be proved. And that's what Judge Matthews is going to tell you. You will learn that the law says that in this situation, there are actually 2 different ways to find this defendant guilty of involuntary manslaughter. You are able to pick either because the law allows you to do so. Involuntary manslaughter is committed when someone's actions or inactions are grossly negligent, or their failure to perform their legal duty as a parent was grossly negligent. That gross negligence caused death, and not the cause. It was a cause of death. And that's important because the judge is going to tell you that there may be more than one cause of death, such as this situation, as long as that other cause was reasonably foreseeable to him, to the defendant. Not to everyone else in the world, but to him. The father who bought the gun, the father who raised the shooter, the father who knew what was going on in his life, the father who suspected him as a school shooter, well before his name was made public, well before anyone from the police department told him it was his son. The law allows multiple people to be held responsible in this case. And that's going to come to you from Judge Matthews. Gross negligence is the failure to use ordinary care to avoid a known danger, even though it was apparent to a reasonable person that serious injury would result. It's the willful disregard of danger. And that, ladies and gentlemen, is why we were here. James Crumbley's willful disregard of danger and his failure to use just ordinary care, when he was the one who knew the background, he was the one that knew the origins of this drawing. Him sitting in that counselor's office, looking at this drawing, and then not only staying silent, but then his failure to act, right there, is his willful disregard of danger, right there. You're going to hear a lot of evidence and arguments in this case. It's important that we all understand that you're not here to talk about, to decide on parenting. This case isn't about parenting. It's not illegal to be a bad parent. It's not kids doing kids' things. We're here to talk about a preventable mass murder. No one will ever suggest to you that every parent can or should be held responsible for everything their teenager does. That's not the law. No one will ever suggest that to you. But in a situation where the father was in a position to reasonably foresee what the son was going to do, because the father armed him 4 days before and was shown a clear statement of intent of what the son was going to do. That is when that rare set of circumstances is present in these specific set of facts. James Crumbley is in charge with what his son did on November the 30th. James Crumbley is charged with what he did and what he didn't do on November the 30th. That is a very important distinction. That is what the law allows. That is what we were asking you to do. This case is not about guns. It's not about even how all guns should be stored in the home. It's not about gun laws. This case is about this gun for this kid with these issues, not secured, when shown this picture. That's what this case is about. When this kid was begging for a more deadly weapon. That's why we're here. I ask that you listen to the testimony, you review the evidence, and you follow the law. If you do that, you will undoubtedly reach a fair and just verdict. If you do that, you will find that James Crumbley was one of the 3 people in this world criminally responsible for what happened on November the 30th, 2021. And you will find him guilty as charged. Thank you.
Thank you, Ms. Lindler, would you like to make an opening statement?
Yes, Your Honor. Thank you.
All right, before she gets started, let's answer some questions here folks had in the chat. Well, here's one right here. Good place to pause for this one. Llama Vomit. Such a funny name. What's the defendant wearing? So he apparently has hearing loss. So those are to help him hear what's going on in the trial. Pond Walden, do you think they would have a lighter sentence if they just pled guilty? Well, if they just pled guilty to the charges, they would. Well, I don't know. Because there would still be a sentencing hearing and everything. So much would come out. Man, I don't know. So I don't know. I can't answer that for you, to be honest. There are so many factors that go into sentencing. And for a case like this, he would still probably get some pretty heavy time if he pled guilty. Rebel Cowboys recreational vehicles. Is it illegal for a kid to own a handgun in that state? It's not here. I believe so. I believe in Michigan, you have to be 18 years or older to own a gun. So that gift to him technically wouldn't have been it's not a legal gift. Madison Cruz. Legalbytes. Nope. Their attorneys told them to stay somewhere else because they could be in danger. They stayed in a building that Jennifer worked at. They did not run. I remember this was argued in Jennifer Crumbley's trial. They made that point definitely, which is an absolutely an important point for the jury to know. That said, I don't think that they bought it in the Jennifer Crumbley trial, and I don't know if they're going to buy it in this case. So it's still a hard series of facts for the defense that I think is still damaging, even if it was at the direction of their attorney. The fact that the state is able to spin it in that way, um, it's still pretty damaging. But let's see. I mean, this jury might think differently than the previous jury. Shiro Kana, whoa, this case, geez. Also, why can't Jennifer C be called? I think I understand why the shooter can't be called minor, but why not her? Minors can be called to testify. The difference is, so for both of them, it's because they have active appeals, which means their Fifth Amendment right still attaches. This is why Hannah Gutierrez Reed would not necessarily be subpoenaed in Alec Baldwin's trial, because her attorneys have said that they plan to appeal. So, but that could be a bargaining token for her to maybe negotiate a lower sentence, if she agrees to testify in his trial, possibly. Jill Prince, why wasn't the school obligated to let parents know there was a concern? The school did let them know that there was a concern. He mentioned in maybe like midpoint in the opening statement that they saw some very troubling drawings on his math homework. Teacher took a photo, sent it to the guidance counselor. Guidance counselor immediately brought in the parents. They had a meeting there at the school, and then he went back. And the thing that is also really tragic here is that no one thought to check his backpack or his locker, considering the seriousness of all of that, to see if there was anything that he could be using on that day, perhaps. I mean, hindsight is always 20/20, but it's really, it's just, I mean, this whole thing is just so tragic. Let's see here. Oh, also, I missed this earlier. Brittany Chanel, are you going to do day 2 as well? I'm not going to be live streaming the whole thing. It's not going to be, sorry, I'm not doing it gavel to gavel, but I will be doing some highlights here and there, and I'm going to do recaps also of this trial so that people can stay on top of the main points. James Carson, is this specific to firearms? So the charge itself is not specific to firearms, but this case is. I'm not sure if that answers your question. Okay, let's see here. I think there was another question there. Perhaps. Okay, maybe not. Okay. All right, let's continue to the defense's opening statement now.
The events of November 30th of 2021 undeniably changed people's lives in ways that most people could never imagine. 4 children lost their lives. Families were destroyed, and a community was terrorized. But this case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. The prosecution alleges that James Crumbley was aware that his son was a danger to others, and that he failed to protect other people from his son. The prosecution alleges that James Crumbley had knowledge that his son could and would hurt other people, and that he failed to protect those people, that he failed to take steps to protect others. And ladies and gentlemen, that simply is not true.
This is definitely a fiery start. And I will say that generally speaking, defense, you'll more often see this kind of fire coming from defense than prosecution. Prosecution kind of has to be careful with that kind of tone sometimes, because of the fact that they are speaking with the weight of the state behind them, the government. Here, I mean, this is she's advocating for one person who is, falling under all of the weight of that government. So this is so far, this is a pretty strong start, that she's acknowledging that this was an absolute tragedy. This was a community was terrorized. And so right here off the bat, I can see that she is probably going to be pointing a finger quite a bit at Ethan Crumbley and saying they couldn't have possibly known this was all a bad egg. He just was a bad egg. And this was like, he didn't communicate these things with anybody else. He was a teenager. Teenagers are often closed off, that kind of stuff. This is a pretty strong start to really get the attention of the jury, and refocus them from her perspective.
We'll hear evidence in this case of what occurred inside of Oxford High School. You will hear the prosecution's version of what they claim James Crumbley may have known. You will hear that a gun was purchased on November 26th of 2021 by James Crumbley. You will hear what kind of a gun it was. It was a handgun. You will hear how it was stored. You may hear where it was stored. You will hear whether or not Mr. Crumbley's son knew where that firearm was. Pay attention also to what you don't hear. Pay attention to that you won't hear that James Crumbley knew that his son knew where that firearm was. Ladies and gentlemen, James Crumbley was not aware that his son had access to that firearm. You will hear testimony that access was not allowed in James Crumbley's mind. Ladies and gentlemen, you will not hear that James Crumbley knew what his son was going to do. You will not hear that James Crumbley even suspected that his son was a danger. That math homework that the prosecution is putting up on the screen, you're going to hear about that. You're going to hear about what other people thought about that. People at the school, including James Crumbley. There's going to be probably quite a bit of discussion about that piece of math homework, ladies and gentlemen, and you're going to hear all about it. Ladies and gentlemen, James Crumbley did not know what his son was going to do. He did not know that his son could potentially harm other people. He did not know what his son was planning. He did not purchase that gun with the knowledge that his son may use it against other people. You will not hear that he did that. The prosecution told you that. The prosecution just told you you're not going to hear that. You're not going to hear that James Crumbley purchased that gun with the knowledge that his son was going to go harm other people. But what the prosecution wants you to believe, the part that's not true, is that James Crumbley knew what his son was going to do and knew that he had a duty to protect other people from his son. Ladies and gentlemen, that's not true. He didn't know. You're going to hear about James Crumbley's relationship with his son. There may be other witnesses who testify about that, about how James interacted with his son, including on the day when that math homework was shown. You're going to hear from other people. They're going to tell you, in their own words, what they observed about James Crumbley and his son, about what they observed about his son, about any concerns they may have had. Other people, not just James Crumbley, but other people with additional education, additional training to evaluate situations like this and evaluate individuals. You're going to hear from those people probably. And they're going to tell you in their own words what they thought about the math homework, about Mr. Crumbley's son, about Mr. Crumbley's interactions with his son. Yes, James Crumbley was a DoorDash driver. We all know that. It's been said multiple times. Ladies and gentlemen, being a DoorDash driver doesn't mean that your job is any less important to you or other people than any other job. It doesn't mean that you don't feel that you have a duty to go to work. And ladies and gentlemen, when you're not aware of an immediate, imminent danger, why would you do anything different than what you normally do?
This is I honestly like this. I like this opening as well. Some folks in the chat don't like her tone. They think that it's a little bit too aggressive, but I mean, when the point that you're making is the state is lying to you, the state is misleading you, the state is not telling the whole story, and it is absolutely unfair to my client. With that kind of a message, I I can buy that tone. I can buy her righteous indignation, of this, to say like, this guy is being steamrolled by the state. WTF. So I don't mind her tone at all. And again, her point here is, the thing that she's really harping on is, he didn't know. That was similar to the Jennifer Crumbley trial, where they said that, I remember in the opening statements there, she was talking about how, she was like a helicopter mom. She was, she was like checking his back for moles or something like that. Which that can also backfire, because it's like, well, if you're that close to him, then you had to have known that this was happening. But here, here it's a different kind of opening. And I like this one. So far, I like this opening statement. But basically what we can see for the jury to expect out of the defense in trial is, there were so many things that he didn't know. There were so many things that he couldn't have known. There's so many things that, with the benefit of hindsight, other people are going to be commenting on that they know, but they have the benefit of hindsight. So yeah, D-Rock 719, why bring up that he's an Uber driver? How is that relevant? So it's relevant because the state is bringing it up as an argument to say he had a super flexible job. Being a DoorDash driver, he's super flexible. He could manage his own hours. He could even have his kid with him in the car. Like he could be really, really watching his kid closely with that kind of a job. And to say that, like, that's all the more reason that he should have known. Maybe not that, maybe the jury finds that compelling, but what she's trying to say here is like, that they're basically steamrolling him for the fact that he was a DoorDash driver. Okay. All right. Let's continue on.
You wouldn't, because you don't have any reason to think you need to. So ladies and gentlemen, you're going to hear the evidence. You've heard a lot of questions in the last couple of days from both the prosecution and myself. You probably have an idea where each side lands on these issues. But you're going to hear the evidence. You're going to hear from people other than us. And you're going to be able to hear in their words what they thought about those days from November 26th to November 30th of 2021. And their feelings, what they observed, any concerns that they may or may not have had. The prosecution has asked you repeatedly to follow the law. I'm going to ask you to do the same thing. Please do follow the law. And I'm confident, we are confident, that if you do that, if you follow the law, that you will find James Crumbley not guilty. Thank you.
Thank you, Ms. Levy. Should I give you a little break?
We had a little break.
Okay.
I'm going to give you a little break.
So very, very short and sweet opening statements for both of them, which personally I love. This is not a case that is like overly complex. And so I think that cases that are not overly complex, like why drag the jury through like a super long opening statement when you don't need to? So this is really about, did he know or didn't he? Should he have known or shouldn't he have known? Or was it okay for him not to know? This is like, these are some of the biggest issues here, because obviously, the other elements of involuntary manslaughter, death was caused. Easy. Yep. Okay. No one's fighting over that. Otherwise, there's, was he grossly negligent? Did he know that there was a risk that was being created by this whole situation that he was participating in? And did he not do what he was supposed to do? Or did he do things that he wasn't supposed to do, knowing that he was creating that risk? So, did he know that his son was having these mental health issues? Is he a particularly dense person? I don't know. We'll see with the evidence that comes out. But, also, was this foreseeable? I think a lot of people would say that kid with like very serious spiraling mental health issues with a friend that, with a friend that has just left, and who's supposedly mentioned to his father that he was having a hard time and dad said to suck it up. That apparently comes from the journal entry, by the way, which is interesting that journal entry is being brought in because, normally that's hearsay, but I guess they're able to bring it in under effect of the listener. Um, Interesting. I'm not sure that I completely buy that, but he's saying this, or I think it was also text messages between him and his friend. But he's saying this. We don't necessarily know that that's true. We can't take that as true because otherwise that's a hearsay statement. So anyway, and question, what is the minimum maximum sentence if convicted? So I don't know what the minimum is. I think maximum is 15 years. I don't know if there is a minimum. Let's see here. Are there other questions here? Soluble hamsters, outrage the best starting point for defense opening statements. I think so. Yeah, absolutely. Because like I said, they're able to rail against the government that is like steamrolling their client, right? They are this is zealous advocacy. I think that was a good opening. I really do. That kind of a fiery opening for the defense. I think it's perfectly fine. Madison Cruz, I've just realized that shootings have happened since Ethan's shooting. I don't recall seeing or hearing about their families. Why do you think they aren't being held to the same standards? It could be that the police investigate what's going on at home and realize the parents really couldn't have foreseen this. The parents, the kid took extraordinary measures to get the firearms, or things like that. That could be the case. I don't know for a fact, but that's if I had to put money on something, that's what I would bet. Shiro Kana, also to anyone, can jurors take notes? Usually they can. Not all jurisdictions are the same. I don't know if they can in this one, but it's a common thing to be able to take notes because there's just so much that goes on in any trial that it's hard to remember things if you aren't able to take notes. So, okay, let's see here. I think one more question here. Tish, do you think he will testify? I don't know. Jennifer Crumbley testified, and I think it backfired. I think it backfired for her, especially because the statement that everybody talks about quite a bit is when she was asked if you could do it all over again, would you do anything differently? And she said no. That's a that's a really hard thing to accept and be like, yeah, we're not going to hold you responsible. I don't know. I think it probably is best if he doesn't testify. But I mean, if they're going with he didn't know, maybe they will want him to testify because he's got to establish to that end that he didn't know these things. I don't know. Tim Harris, thanks for the super chat. I thought peremptories could be any reason. Does that reason have to be disclosed? It can be any reason. It just can't be, like I said, an illegal reason, like some kind of discrimination. They don't have to be disclosed as far as I know, in my experience. But you can sometimes have a suspicion if the last question is like, what's your religion? And then and then you move to strike that juror. But yeah, they to answer your question, they can be any reason, so long as it's not illegal. Okay. All right. So that's the end of the opening statement, you guys. Thank you so much for your questions. Thank you so much for joining me. Thanks for those that joined Bite Club or bought memberships for other people, and for the super chats, you guys. Awesome. Thank you also to the mods, as always, for helping to make sure that everybody agrees and disagrees in ways that are productive. We are definitely going to be continuing to cover this trial. I think it's a very interesting case. And yeah, let me know what you guys think. Oh, I didn't do a poll at the end. We'll do a poll at the beginning of the next live stream that we do. How about that? This was the results of the first poll was 46% of you said guilty, 11% said not guilty, 42% said it's too soon. And short and sweet. Thanks, Alita. When can we expect another live? Yeah, no problem. This was I just wanted to get a quick one out there for you guys. Another live sometime next week for sure. We'll definitely be doing on Monday. We've got classic trials, which we're still going through the Menendez brothers trial. So that is going to be happening on Monday. Other than that, we're going to be doing more uploads and probably a mix of uploads and live streams for this case, maybe for some other cases as well in between. But yeah, for sure, more live streams next week. All right, guys, this has been wonderful. Thank you so much. And I'll see you guys in the next